What's up, everybody? It's a late night, a last minute live, but I saw the bat signal. I happened to be working. My wife and kids are out of town. Had an epic night of pickleball, went home, showered, decided to come back here, do a little work. Saw people, dropping some hints that there have been some new filings. And then I heard a motion to dismiss the grand jury indictment. And I thought, wow, what do they got? July 21st, I think, is when they got the grand jury documents, materials, testimony. What did they find? Is it legit? Do they have a shot? I have not read this document. It's 20 something pages, but I figure let's come hang out. I'm at the office. I'll read it with a few thousand of my friends here. And I mean, if this doesn't get you to hit like and subscribe, that we're coming in at almost 11 o'clock at night Eastern on a work night, right? To come hang out with you all as soon as this dropped, or as soon as I saw it, I should say. As soon as I saw it. So let's talk about it, because I've been waiting for what they're going to find, if anything, if there are issues in this motion to dismiss. Melanie, what's up? I feel like it's been a while, Melanie. Glad you're here. At least that I've seen you in the chat. So people said I read it. I'm so confused. Hopefully I can help with that. We will see. All right, let's get to it. Let's get right to it. Kohberger's motion to dismiss. All right. Buying through his attorney. Here he goes. Motion to dismiss issues. Here we go. This is what it's all about. The Idaho Constitution, Article 1, Section 8, set the standard of proof for a grand jury at beyond a reasonable doubt on the plain language of the statute. Is that right? Is that right? Beyond a reasonable doubt for the grand jury? I did not know. I did not think that's what it was. I thought it was like probable cause, more similar to that. All right. The legislative history also supports a beyond a reasonable doubt standard. The Idaho Supreme Court cannot adjust the standard of proof, as it is a substantive right. The failure to properly instruct a grand jury as to the standard of proof is grounds for dismissal of the indictment. The grand jury was erroneously instructed with the standard required for a presentment. Thus, this court could treat the indictment as a presentment. All right. Color me confused at the start, people. Color me confused. I will say, if they failed to properly instruct the grand jury as to the standard of proof, that would absolutely be grounds for a dismissal. But just off the issues, which is just kind of like a quick summary type of deal, it sounds like they're saying their argument is the burden of proof is beyond a reasonable doubt for the grand jury, which we'll see. We'll see. But I think that's what they're getting at. They're saying they should have said it was beyond a reasonable doubt. They didn't. Therefore, you have to throw out this indictment. My guess is when we get to the end of this document, I will be surprised if they make an argument where I'm saying, yep, the burden of proof is beyond a reasonable doubt for a grand jury. But let's read the argument together. The Idaho Constitution set the standard of proof for a grand jury at beyond a reasonable doubt. The grand jury ought to find an indictment when all evidence before them, taken together, if unexplained or uncontradicted, would, in their judgment, warrant a conviction by a trial jury. Okay, we're half a page in here. We're half a page in here, and I'm already pausing a lot to think. Okay, I'm pausing a lot to think because this is a new one for me. They're saying the Idaho Constitution says the standard of proof is beyond a reasonable doubt. And then we read the section that they cite, and it doesn't say the standard of proof is beyond a reasonable doubt. I think what they're trying to say is if the evidence before them taken together, if unexplained and uncontradicted, would warrant a conviction by a trial jury, and to get a conviction by a trial jury, you need proof beyond a reasonable doubt. I think that's the argument they're trying to make. I think they are wrong. Of course, I could be wrong, right? Not in Idaho. This is a new one on me. But let's keep going. The statute was in existence at the time the Idaho Constitution was adopted. When construing the Idaho Constitution, the primary object is to determine the intent of the framers. Provisions of the Idaho Constitution must be construed in light of the law prior to their adoption. Even Idaho's Constitution reflects this view. All laws now in force in the territory of Idaho, which are not repugnant to this Constitution, shall remain in force. In Clark, our Supreme Court found a statute in force at the time our Constitution was ratified to be controlling in its interpretation of Article 1, Section 17. In State v. Matthews, our court considered the issue of whether such search warrants needed to be signed in order to be valid. The court found that warrants do need to be signed, or else a search pursuant to such a warrant will violate Article 1, Section 17 of our Constitution. The court arrived at this conclusion despite the fact that Article 1, Section 17 is completely silent regarding whether a warrant needs a signature. The reason the court was able to find a constitutional violation in this case was by acknowledging that the statutes which require a signature predate the Constitution of the state of Idaho. Because these statutes which require a signature on warrants predated the Idaho Constitution, they create a substantive right which existed prior to the adoption of this state's constitution. So basically the argument is if something predates the Constitution, then it is a substantive right. Okay? Haven't heard beyond a reasonable doubt yet. Our Supreme Court found a defendant was entitled to a constitutional relief for a violation, a knock and announce, after finding the rights contained in the statute were long-standing at common law and deeply rooted in our heritage. The Roush Court was able to trace this deeply rooted heritage all the way back to 1603. Oh boy. Oh boy. When we start citing case law from 1603, that's not usually great. That's not usually great. Thus, whatever this language means, it must color this court's interpretation of Article 1, Section 8. The section states, no person shall be held to answer for any felony or criminal offense of any grade unless on presentment or indictment of a grand jury or on information of the public prosecutor after a commitment by a magistrate, except in cases of impeachment, in cases cognizable by probate courts or by justices of the peace, and in cases arising in the militia when in actual service in time of war or public danger, provided that a grand jury may be summoned upon the order of the district court in the manner provided by law, and provided further that after a charge has been ignored by a grand jury, no person shall be held to answer or for trial therefore upon information of public prosecutor. So it seems like indictment or preliminary hearing, but they also have something called a presentment, which is going to come up later, I assume. If it were not clear from the text, the framers' general intent behind the section was to ensure that either a grand jury or a magistrate stood between the prosecutor and the accused. True. Thus, it stands to reason that the standard of proof in effect at the time of the adoption of the section was incorporated into it. It would be rather ineffective to create a buffer between the government and the citizens that the government could change willy-nilly. Willy-nilly. However, that does not provide much information as to what standard would warrant a conviction by a trial jury actually means. I get what they're trying to get at here. To get a conviction from a trial jury, it would need to be beyond a reasonable doubt. Okay? The interpretation of the statute must begin with the literal words of the statute. Those words must be given their plain, usual, and ordinary meaning, and the statute must be construed as a whole. If the statute is not ambiguous, this court does not construe it, but simply follows the law as written. We have consistently held that where statutory language is unambiguous, legislative history and other extrinsic evidence should not be consulted for the purpose of altering the clearly expressed intent of the legislature. The plain text of IC whatever sets the standard of proof that would warrant a conviction at trial. The justification for a conviction at trial is and was proof beyond a reasonable doubt. Okay, so that is what they're going for. That's kind of the definition they came up with. The fact that they even say we got to figure out what this means, yet then they say that it's unambiguous because the court and the judicial branch interprets the law. They don't write the law, but it's also throughout statutes, laws, constitutions across the country that beyond a reasonable doubt is only when life, liberty, and the pursuit of happiness basically is at stake. And that's in criminal cases, not civil cases. And a grand jury indictment does not mean somebody is convicted of the crime. You could be indicted by a grand jury and theoretically get bail and go home and still be living in society and still have your job and still have no issues. You're just waiting for trial. That's the point of the high standard of beyond a reasonable doubt. I'm just, by the way, it's 11 o'clock at night. We're hanging out, just spitballing here, just spitballing because it's the first time I'm reading this, first time going through this. So I'm just thinking through my head where we get these burdens of proof, why we have them. And I would never think beyond a reasonable doubt is the burden of proof. Not that I'd be opposed to that. It's just a prosecutor. It's a one-sided trial. They should have to prove it beyond a reasonable doubt. Sweet tea for an iced coffee tomorrow. Thank you for this late live. I'm going to need it, sweet tea. I don't like sweet tea, but if I did, I'd buy one because of your name. Net woman. Did Daryl Brooks join the defense team? Glad you still have a voice, Peter. Yeah, I do feel like it's kind of starting to go. But the only live I'm doing tomorrow is the 250K celebration. So that'll be fun. Azam, thank you for the super sticker. Yeah, my voice goes too when I play pickleball with my buddies. I actually see Jeff in the chat, and we're not going to respond because he's telling half truths. Jeff is one of the guys I played pickleball with tonight. Doris, hey, Peter, I'm so glad to catch your podcast. Really makes my day. You cover everything I follow. Thanks so much. Have a blessed day. Thank you so much, Doris. Jeff throwing out numbers that don't make sense. All I know is only one team won 11-1 tonight. And that was me and Lucas, who all of you may remember from the pickleball video. Hit that like button for me. 2,500 here in the chat. Let's get to 2,000 likes. All right. So let's keep going. If that were not enough, well, sir, I don't think that's enough. Section 191107 is one of the many laws that were adopted in 1863 and 64, copied verbatim from laws adopted in 1851 in the state of California. The Idaho Supreme Court has held, this court has consistently held that a statute which is adopted from another jurisdiction will be presumed to be adopted with the prior construction placed upon it by the courts of such other jurisdiction. This is making me interested to go across and see if anybody has this as a standard of proof in their grand jury process or preliminary hearings or things like that. I don't know. All right. The defendants were indicted for murder in all these cases and arrested. They applied for bail but were denied. On a habeas petition challenging the denial of bail, the California court took time to discuss the legal standard required for finding an indictment. Okay, here we go. Formerly, an indictment was regarded as a mere accusation, which the grand jury ought to find if probable evidence were adduced in support by great authorities, says Chitty, have taken a more merciful view of the subject, and considering the ignominy. This is going to be brutal. They're talking about 1826. These cases are from 1862. Oh, this is not going to be fun. The dangers of perjury, the anxiety of delay, the misery of a prison, have argued that the grand inquest ought, as far as the evidence before them goes, to be convinced of the guilt of the defendant. What was therefore anciently said respecting petit treason may be applied to all other offenses, that since it is preferred in the absence of the prisoner, it ought to be supported by substantial testimonies. The more merciful view of the subject, I don't know why I keep saying suspect, thus referred to, is secured by statute in the state. Our Criminal Practice Act declares that the grand jury shall receive none but legal evidence, and the best evidence in degree, to the exclusion of hearsay or secondary evidence. And though not bound to hear evidence for the defendant, that it is their duty to weigh all the evidence submitted to them, and when they have reason to believe that other evidence within their reach will explain away the charge, they should order such evidence to be produced, like an alibi or Brady evidence, exculpatory evidence. And that they ought to find an indictment when all the unexplained or uncontradicted evidence warrant a conviction by the trial jury. And of course, ought not to find an indictment when the evidence taken together, if unexplained or uncontradicted, would not warrant such a conviction. The indictment is then something more than a mere accusation based upon probable cause. It is an accusation based upon legal testimony of a direct and positive character, and is the concurring judgment of at least 12 of the grand jurors selected to inquire into all of the public offenses committed or triable within their county, that upon the evidence presented to them, the defendant is guilty. So what's interesting about this is it needs to be something more than a mere accusation based on probable cause. Clear and convincing evidence is more than probable cause. There are standards that are above probable cause that are not beyond a reasonable doubt. Thus, the only case on point from the time this statute was adopted clearly states that the standard for finding an indictment is higher than the probable cause standard. I agree, if that's really how we're going to do this, taking a case from 1826. In addition, other jurisdictions and legal treatises have recognized that the plain language amounts to more than probable cause. The defendant does not, by all this, intend to bury the lead, but merely show that under the usual approach to statutory interpretation, there is no reasonable doubt as to what a grand jury should be instructed. That said, the defense recognizes that the whole of modern jurisprudence on this issue is against it, as well as at least one founding father of this state. Okay, so maybe I'm not crazy. Maybe I'm standing with the whole of modern jurisprudence as I stand against the defense on this issue. I mean, we probably could stop reading there. We're only on page 6. I'll continue on, but it seems like the defense realizes and admits this probably isn't going to happen for them. Crime Sleuthin, thanks for always providing cogent explanations. Appreciate you. Kendall Pittman, best lawyer on YouTube. Thanks for all you do. Thank you, Kendall. And thank you, Denna. All right, the legislative history also supports a beyond a reasonable doubt standard. Here we go. The history of this formulation shows that the abandonment of the standard at the retreat to common law probable cause has no basis in law. To begin, the formulation first appears in 1850 in the Code of Criminal Procedure of the State of New York. Okay, so we have 17 more pages, and I think they're about to go through the legislative history dating back to 1850 and use that to go against the whole of modern jurisprudence. All right. The Idaho Supreme Court and the United States Supreme Court have acknowledged that this state has retained the language from the Field Code in its procedural statutes. To understand why the Field Code broke with common law, it helps to have some knowledge of the history of grand juries and the considerable concern about them occurring in the latter half of the 19th century. In England, you never want to bring it back to England. I'm sorry if I'm being too snarky as we read this, but this is not good. This is not good. One man's opinion. All right, what did they do in England? In circa 1978, began with a group of 12 that went on to evolve into a grand jury. The grand jury considered from a historical, political, and legal standpoint. The alternative arrived with a Norman conquest, in which the accuser could raise the hue and cry, and if successful, force the accused to choose between a guilty plea or a trial by combat. All right, English history. I'm going to skim through some of this. Sorry if that annoys anybody. At the time of this country's founding, colonists had at least we got to America now, had knowledge of this history and experience with the power of the grand jury to prevent government abuses. More importantly, the colonies had experience with something that never took hold in England, a local public prosecutors. While the development of the magistrate's power to dismiss felonies after a preliminary hearing in England is mostly lost, in America, a number of historical writings shed light on what was known to those that adopted the Constitution. There are, however, a few known exceptions to the English procedure. In Massachusetts, the examination procedures seem to have permitted witnesses to be questioned in the presence of the accused. The early New Haven colony departed further from the English model than most colonies. Here, the justice, or more often the justices, were formally permitted to dismiss charges when they became convinced of an accused's innocence. The Virginia county courts initially appeared to have examined arrest suspects to determine whether the accused should be tried before a general court. 1705, are we going backwards? The new institution, the examining court, was introduced after a preliminary hearing before a justice of the peace. The case was sent to a special examining court, where the accused was again questioned by several justices of the peace. Here, the accused was entitled to require the sheriff to summon witnesses on his behalf. Either the accused was released or the case went to the grand jury and eventually to a trial jury. In spite of their experience with the discretion of the public prosecutor and the protections afforded by a preliminary hearing, it was the grand jury that the colonists looked to for protection from government abuse. Okay, and this is just more about how the founding fathers felt like a grand jury was so important to protect us from the government. Okay. All is not well with grand juries by 1850. People strongly argued that the entire jury system should be abolished. American jurists and lawyers were becoming all too aware that grand juries would indict whatever they were told or wanted to indict. Thus, it is unsurprising that the Field Commission wrote in their code, in approaching the subject of the powers and duties of the grand jury, the commissioners have felt much embarrassment and have therefore devoted to it the patient and laborious consideration which is demanded. The value of this institution is at the present day variously regarded. By some, it is deemed of the highest importance as furnishing, by reason of its secrecy, a most valuable aid in the efficient detection of punishment of a crime, while by others it has been regarded, by reason of that very secrecy, as submersive of the rights and destructive of the liberty of the citizen. Amy D said late night class with Peter. Yeah, this does feel like late night class. Nalas, does this change your perspective of guilt? No, he's presumed innocent. As we sit here right now, he's innocent. I don't think he's going to win this motion to dismiss. He may very well lose the trial. I'm not saying he's going to win the trial. I'm not saying he's going to lose the trial. This does not affect my opinion of the trial at all. We're just talking whether or not we think he's going to get this grand jury indictment dismissed. I don't think so. Maybe the court's going to buy this argument. 40 Daughtry. This sounds vaguely sov sit. Not quite, but sounds like they're trying to take us back. Did Chat GPT write this? Makes sense, right? Because they stop at a certain date, right? I don't think it's quite 1850. Do you think they're just reaching at this point? The one thing I guess I could draw from this is maybe they looked through the grand jury proceedings and they couldn't find anything else. That's the one thing I guess we can draw from this. Welcome to all the new members, including Arthur. Yeah. Pat Bosch, let's read the phone book next. I'm trying not to bore you, but I agree with you. Some of this is tough, so we'll skip some of the boring stuff. All right. With this background, it's easy to see why the Field Commission chose to implement new rules for the grand jury. The authors decided that a grand jury should not admit hearsay, that it should be required to look into exculpatory evidence if it comes across any in its investigation, that its decisions should be challengeable, and as a concluding rule on this subject, grand jury should be distinctly informed by the law that they ought to find an indictment when all the evidence taken together warrant a conviction by a trial jury. We have that memorized by now. The attempt to save the grand jury was adopted by California. In 1862, California Supreme Court recognized the importance of the language. The Supreme Court likely incorrectly ruled that the grand jury requirements in the Fifth Amendment did not apply to the states, evidently convinced that the common law way of running grand juries was not worth preserving. In 1889, founders of our Constitution got into an argument about the necessity of a grand jury. It is somewhat evident they're proceeding in debates is what they're citing here. It is somewhat evident from the debate that not all parties were fully aware of the controlling law on the issues. One member apparently not aware of who hurtado had been decided. More to the point, William Claggett of Shoshone County told the assembly that all the grand jury is entitled to do to say there is probable cause to believe the man is guilty. While it is true that Mr. Claggett was an accomplished criminal defense attorney, it seems clear that he had little experience with the field code. Luckily, we're all getting experience tonight with the field code. His statements to the assembly show he did not know a presentment from an information. This should be somewhat unsurprising, as California was the first state to adopt the field code, largely because Dudley Field, the father of the code's brother, was in the California legislature and later was the fifth justice named to the Supreme Court. History lesson. Perhaps also unsurprising, Justice Field authored People v. Tinder and Smith, which again they've cited here. Regardless of whether Claggett was aware of the laws of the state he was founding in 1889, the practice of prosecution in the aftermath showed what is clear from the statutory language. The standard for the grand jury is beyond a reasonable doubt. Here's what I hate. Don't tell me something is clear. Don't tell me something is clear when it is clearly not clear. Okay? I really don't like when people tell me that something is clear when it's not clear. Maybe I'm slow, and sometimes that happens, especially when it's late. Diana, my attorney and I talk about this case all the time. We both have gut feelings that he's innocent. Thank you for breaking this case down. I work at a criminal law office, and this case still confuses the heck out of me. Thank you, Diana, for the comment. I don't have any gut feelings that he's innocent or anything like that. I would just say that this case should be held to a standard, needs to be proven beyond a reasonable doubt. They need to cross all their T's, dot all their I's, get all their ducks in a row, do it within 6 months. Let's get this trial done in a speedy trial period. If that's what he's demanding, that's where I feel. That's really the only gut feeling I have about this case. Will the state's response, or wait till the state's response sent from my iPad? We are probably not doing anything else tonight besides this. And cool name and picture there, Papa Roger. Sportsy girl. Thank you so much, Peter. Been waiting, hoping you'd cover this tonight. Please tell me you'll translate to layman's terms. This is making my head spin. I got to be honest. Old English is not my forte. It seems a little bit like that's where we are going. So let's continue on. It appears the first Idaho case to mention this was Gasper. In Gasper, a defendant was indicted by a grand jury. The defendant filed various motions to set aside the indictment. The court found that the defendant failed to raise any valid challenges to the indictment. After concluding that the defendant failed to raise any valid challenges, the court quoted an intrusion that the grand jury should not find an indictment unless you are satisfied beyond a reasonable doubt from the evidence from the government presents that the defendant is guilty. It's back in 1953. We're getting to closer to modern times. The court then said in dicta that the instruction is more favorable to one accused before a grand jury than it would be a charge embodying the statute. The court then quoted and again said in dicta, the charge as given calls for a greater degree of proof to justify an indictment than the statute requires. No further analysis is provided by the court as to why the two standards would be different, nor does the court even attempt to identify what the proper standard would be. Okay. The next Idaho case to mention this distinction, in Bullis, a defendant was charged via grand jury indictment. The defendant alleged that the grand jury had received hearsay evidence in violation of 1911-05. However, the court disposed of this argument because appellant has presented no record on appeal of what evidence was before the grand jury. Despite disposing of this argument, the court then made the following comment in dicta. Idaho Code Section 1911-02 only requires that the grand jury find that there is reasonable ground for believing that a particular individual named or described in the presentment has committed a certain public offense. And that's the problem. I mean, anybody who's tried a case knows that you do your best to explain what the burden of proof means, but it is very difficult. Like if I explain it to you and then had you explain it back to me, the difference between greater weight of the evidence, clear and convincing, beyond a reasonable doubt, probable cause, any of those burdens, I think it's very difficult to differentiate between them. I think if you're on a jury, you want to feel like you know that your verdict is right. That's what you want to know. And what that means in your gut, like most of my cases are civil, so it's greater weight of the evidence. Most of the cases I used to try were criminal. So I would say the highest burden in any court, in any judicial system across our country is beyond a reasonable doubt. And now what I try to say is I try to just make that burden seem so low. The greater weight of the evidence, more likely true than not true. You can believe a lot of what the other side says, just as long as we're a little bit ahead of them. Just a little bit ahead of them, we win. You don't have to be positive. And it's really hard for people. It's really hard for people to differentiate between those things. And I'd be willing to bet if this did get dismissed and there's a new law in the land of Idaho that by the way, this could create some serious precedent and other issues in other cases, right? But if they created this and now it's beyond a reasonable doubt, I would be willing to bet it would not change the example. I'm sorry. It would not change the outcome. I'm reading the chat at the same time. It would not change the outcome. I think you go before a grand jury, you tell them actually the burden of proof here is beyond a reasonable doubt. Let me explain this case to you. No defense here, no defendant. They're still going to convict or indict. That would be my bet. Angel D, won't this kind of annoy the judge? No, I don't think it's going to annoy the judge. I think he's going to read it. He's going to consider, he's going to think. Listen, new arguments are made all the time. Sometimes they win. Most of the time they don't. Most of the time judges don't want to be the ones to make some new law, but sometimes they win. Does BK have a choice between jury and judge? He has demanded a jury trial, I believe, at this point. In order to go before a judge in most jurisdictions, both sides have to agree. If either side demands a jury trial, you go to trial by jury, usually. Crime sleuthin'. The Lady Anne doth protest too much, methinks. Chase. I moved to the final round of jury selection for a murder trial today, really hoping I survive for hire. Any advice? No, Chase. No advice. I do not want to talk to you about it. Do not talk to me about it. Do not tell us anything in the chat about it. Be fair, be impartial, just listen to what happens in the courtroom. Do not talk about it with anybody while you're moving through jury selection. Let's make sure we keep things pure and unadulterated in the courtroom. Lucia, Ridiculous, every grand jury in Moscow would be overturned. Real speaks. I listed a sealed TV stand on eBay. Shortly after, the TV stand company told me they would sue me if I didn't take it down. Could they actually do that? I don't know, Real speaks. I'd have to ask a lot more questions. John, do you think this is a clever move? Interesting to discuss. No, I don't find it clever. I don't love stuff like this. To me, again, I have to wonder if this case wasn't being so highly publicized, would they have filed this? I would also wonder if I was another one of their clients in the public defender's office and I was charged by a grand jury indictment and it was the same as this and they didn't file this motion, I would have some questions. I would say, yo, Ann, Jay, what's up, man? Can't you file this for me too? If they think this is a legitimate argument. Starla, I'm headed out. Enjoy the reading, folks. Peter, thank you for your knowledge of the law. Just can't listen to 1800s law. Good night. See y'all tomorrow. See you, Starla. I understand. I do not blame you. All right, let's get back to it. The obvious and glaring error in this statement is that the court did not quote the standard required for finding an indictment. It quoted the statute defining the standard required for finding a presentment. Again, no further analysis was provided by the court as to why it would be quoting the standard used for a presentment when an indictment was at issue in the case. One possible explanation is that neither party brought to the court's attention that Idaho actually has two separate statutes defining the standards for indictments versus presentments, since the question that was not presented as an issue on appeal. So what I will say is they should look at this and they should make it more streamlined and make it uniform. Finally, the distinction was again mentioned in State versus Edmondson. In Edmondson, the defendant challenged the grand jury indictment as a violation of the equal protection rights. The court quickly disposed of the argument by stating that Edmondson's failure to request a preliminary hearing is dispositive of this case. However, the court then continued by taking a more in-depth look at the equal protection argument. While doing so, the court made the following comment in dicta. By the way, if you're wondering what dicta is, it's basically discussion by the court. It is not a holding or a ruling or precedent that must be followed by lower courts. It is not the same thing as an actual decision made by the court. And it can be instructive in cases when you're making arguments. It can sometimes be persuasive, but it is not binding on other courts. And sometimes it's not even persuasive. The purpose of both grand jury proceedings and a preliminary hearing is to determine probable cause. No explanation or citation given for this statement. So again, this is not going their way. Several pages down in dicta, they said the purpose of the grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. Again, no explanation. Several pages later, the court briefly discusses the issue of prosecutorial misconduct. During this discussion, again in dicta, the court says, we note that the prosecutor directed the grand jury that it should not indict unless all elements for an alleged crime are proven beyond a reasonable doubt. This is a much higher standard than is required by Idaho law. Again, no explanation or citation was given for this comment. One feasible explanation for why the court in Edmondson was of the belief that only probable cause was required for the finding of an indictment is that the time Edmondson was decided, Idaho had now adopted Criminal Rule 6, which provided that an indictment could be found if there was probable cause to believe that the accused had committed the crime. The court did not explicitly cite the rule, but the rule was in effect at the time of Edmondson, which I think means it's still in effect right now. Oh, here we go. So here's the next argument. The Idaho Supreme Court cannot adjust the standard of proof as it is a substantive right. So the next issue is going to be, we all agree at this point that the Idaho Supreme Court said it's probable cause for a grand jury indictment. Seems like everybody agrees. Seems like that's why they're saying that other court got it wrong. But they're saying the Idaho Supreme Court should have never been able to do that. It shouldn't have done it, period. AZ, if Judge cleaned toilets for a living, he would be called John. Thank you. It's exactly what we needed in the middle of this. Brooklyn Basement, what would you have done different in this motion? Honestly, Brooklyn Basement, I can't answer that because I don't know what's in the grand jury documents, materials, proceedings, and transcripts. So I don't know if I would have found something different. I would not have made this argument personally. So if it works, Kudos. Hats off to them if it works. New Chris is just checking in. Glad you're still here, new Chris. Not to be confused with old Chris. And thank you, Lisa. All right. Despite the fact that Idaho Code Section 191107 explicitly sets the standard of proof required for an indictment, approximately 100 years after Idaho codified the standard to be applied, our Supreme Court adopted ICR 6.5 that states that a grand jury ought to find an indictment when there is probable cause, which is basically how all of us thought it was happening, to believe the defendant committed the offense. It is therefore necessary to determine what standard governs the statute or the criminal rule. So here we go. Now begins this discussion. The court's rule-making power goes to procedural as opposed to substantive rules. Thus, I'm literally having this argument. It's really funny. Tort reform is happening in Florida right now. We are literally litigating, fighting, having motions and hearings about the differences between procedural and substantive. Substantive is things that completely change the case. Prejudice, if something changes and you change the substantive law and apply it retroactively, can't happen. Procedural is just changing procedure. That can be applied retroactively. And like the way you have to file things, or you got to answer in 30 days or whatever it may be, versus the statute of limitations. That's substantive. Just to give you a quick example. This court's rulemaking power goes, I already read that. Thus, if the statute speaks towards a substantive right, it will prevail over a contrary criminal rule. But if the statute speaks only towards a procedural right, the criminal rule will prevail. Although a clear line of demarcation cannot always be delineated between what is substantive and what is procedural, the following general guidelines provide a useful framework for analysis. Substantive law prescribes norms for societal conduct and punishments for violations thereof. It thus creates, defines, and regulates primary rights. In contrast, practice and procedure pertain to essentially mechanical operations of the courts by which substantive law, rights, and remedies are effectuated. The standard of proof for finding an indictment is not a procedural right. Oh, it's not a procedural right, right? They're saying it's a substantive right. It does not deal with the manner of service or time for appearance, nor is it a matter of practice and procedure in all actions and proceedings. So I will also tell you, as we talk about this, it's always a gray area. There are always arguments on both sides when you start getting into whether or not something is substantive or procedural. The grand jury statute sets out the substantive rights of every citizen that must be followed before any citizen can be held to answer on a felony charge. This is a substantive right in that it grants every citizen of Idaho the right to not be held to answer on a felony charge unless the standards set out in Idaho Code Section 191102, 1007 has been met. Were this only a matter of procedure, every citizen of the state would be subject to detention to answer for a felony charge based upon the whims of the Supreme Court. Okay, so here's the other issue. He mentioned before that when things can be confusing or there are gray areas, the court steps in and can help define them. And they're putting this entire argument on the fact that this is clear. There's no reason to even discuss it. And because it's so clear that it's beyond a reasonable doubt, the fact that the court came in and completely changed that is so unfair. On the other side, if it was ambiguous and the court felt like they needed to make it more clear and they made this rule that said it's probable cause, it's probably probable cause. And that's, I think, where I land here. And they haven't really pulled me on their side very much at all. Standards of proof are considered substantive in every context, except apparently in dealing with conflicts of law. So even if it is a standard of proof is considered substantive, was there a clear set standard of proof based on the Fields law or whatever it is that we read that said it would warrant a conviction by a trial jury higher than probable cause? The Idaho Supreme Court has found it is a procedural issue and the standard of the forum state applies. So it sounds like they've already found that it's a procedural issue in dealing with conflicts of law. The United States Supreme Court, meanwhile, vehemently disagrees. In 1942, the court found that the standard of proof is part of the substance of a claim and cannot be considered a mere indictment of a form of procedure. The court has followed that holding in various cases thereafter. So the Supreme Court says the standard of proof is part of the substance of a claim. Okay, that's important always. What the United States Supreme Court says is not just suggestive. It's not just something that is convincing, but it is, in fact, ruling law that you must follow. However, we deal here with criminal law. Counsel can find no case that permits the courts to determine the standard in a criminal matter. Oh, so those were civil cases. Most recently, the United States Supreme Court considered standards regarding defenses in criminal action and never once indicated it was not for Congress to set the standard because it is a power belonging to the judiciary. So they're saying they confirmed that the court should not change the standard because they never once indicated that. It appears from the authorities that courts set the standard of proof by rule only in situations that are themselves creatures of procedure, like the standard to create a class in a class action, or the standard to show a past conviction is admissible under the evidentiary rules. If that were not enough, several important constitutional provisions should be kept in mind when considering whether the standard is substantive. First, our Constitution provides that all laws now enforced in the territory of Idaho shall remain in force until they be altered or repealed by the legislature. Second, the legislature shall pass all necessary laws to carry into effect the provisions of the Constitution. Finally, the right to have a grand jury make either a presentment or indictment finding prior to being held for trial is an Idaho constitutional right. And therefore, they're saying should be held by that standard, not the new criminal rule. These provisions have important implications on this case. The section 1102 and 1107 were in force at the time our Constitution was adopted. They shall remain in force until they be altered by or repealed by the legislature, not simply until the judiciary decides to alter them, but until the legislature amends or repeals these statutes. This happens all the time where people feel like the courts are making law instead of interpreting it. That's part of the balance of powers. The legislature is supposed to make law or write law, and the judiciary is supposed to interpret it. Second, because the legislature was charged with passing all laws necessary to carry into effect the provisions of our Constitution, and because the right to a grand jury presentment or indictment is most certainly a constitutional right, it necessarily follows that it is the legislature who has authority to pass laws and will breathe life into the Constitution, into that constitutional right. To simply say that a person has a right to a grand jury determination means very little unless we define what a grand jury determination even means. If our Constitution simply provided for the right to a grand jury, but no law set out what that meant or what findings were necessary, the right conferred in Article 1, Section 8 would be meaningless. This is why Article 21, Section 15 leaves it to the legislature to pass laws defining what is meant by the constitutional right. It is not the judiciary that is given the power to carry into effect our constitutional rights. It is the legislature. This is one of those things where it's like they're making all of these arguments, but I think they lose before they even get to these arguments. That's the problem. All right. Third, because the right to a grand jury is preserved in our Constitution, and because at the time of our Constitution, 1107 defined what these rights meant, it must be construed in light of the law prior to its adoption. What this means is that Idaho Code Section 191102 and 1007 are actually much more than mere substantive statutory rights. They are actually incorporated into and part of our substantive constitutional rights to a grand jury. Okay. The failure to properly instruct the grand jury as to the standard of proof is grounds for dismissal of the indictment. This, I think, is pretty easy. If they actually got the standard wrong, if it was supposed to be, let's say it was supposed to be probable cause, and they said, you just have to kind of feel like this might be right, and they misstated the standard of proof, then you better believe that this would be dismissed. If they actually screwed up the standard of proof, I absolutely believe this indictment would be dismissed. I just don't think they screwed up the standard of proof. Grounds for setting aside an indictment. The indictment must be set aside by the court in which the defendant is arraigned upon his motion in either of the following cases: when it is not found, endorsed, or presented as prescribed in this code; when the names of the witnesses examined before the grand jury or whose depositions may have been read before them are not inserted into the foot of the indictment or endorsed thereon; when a person is permitted to be present during the session of the grand jury; and when the charge embraced in the indictment is under consideration, except as provided in Chapter 11 of this title; when the defendant has not been held to answer before the finding of the indictment on any grounds which would have been grounds for challenge either to the panel or to any individual grand juror. A motion in arrest of judgment is an application on the part of the defendant that no judgment be rendered on a plea or verdict of guilty, or on a verdict against the defendant on a plea of a former conviction or acquittal. It may be founded on any of the defects in the indictment that are grounds of demur, unless the objection to the indictment has been waived by a failure to demur, and must be made before or at the time the defendant is called for judgment. Neither of these statutes was intended to create a mechanism for challenging the instructions given to the jury. The Court of Appeals in New York found as much, but concluded that defendants could still move to quash a warrant where the proceedings intrude on their constitutional rights. The court then found that a showing that an instruction was prejudicial and it may require an indictment to be quashed. I think that's totally fair, and I think the court would make that decision if, in fact, of course, that was the case. EDB is in the chat. What's up? I haven't been watching the chat as much because I'm reading, and whenever I'm reading, it's hard for me to follow the chat, and I was on my own until 5 seconds ago where John just jumped in and joined us. So normally the writing is concise. This is something. This is like their time to shine or something. I don't know what they're trying to do. I don't know. Rob's brain hurts. My voice hurts. Sweet Tea needs a Tylenol. She's making sure I get a Tylenol. I'll be good. I read a lot for a living, but not so much out loud. Diana's thinking this motion to dismiss is going to get denied. I think I'm with you. Caitlin, in a day of unpredictability for me, tuning into your stream is such a relief and educational. Keep on keeping on. Caitlin, I'm glad you're here. And we've got just a few more pages to get through. John, isn't this the right move or only move by Ann Taylor to represent her client, even if it's a long shot? Thanks for your great input. So, John, here's what I'll say. I do think sometimes people take it a little too far to say, well, it's a defense attorney's right to zealously represent their client. That is true. I believe that with my whole heart. I think they should hold the state's feet to the fire. They should make sure everybody proves everything appropriately. They should make sure law enforcement does everything appropriately, that no corners were cut. But you do not have to try to make legal arguments that do not make sense. I don't know if I'll go as far as to say this one doesn't make sense, but I should not, because it may help my client. We just heard the congressional hearings on a UFO or whatever. I didn't watch it. I should not make the argument that aliens came and on that UFO, they took my client up there and therefore they're insane, so they're not guilty by reason of insanity. Or they dropped off an alien. That alien actually committed the crime. Could that help my client if I win? Sure. That doesn't mean I should do it. And I know that's not what you're saying, but sometimes I do think people take that a little far. You should not scream at the judge. You should not be disrespectful. Maybe that would help your client. Maybe the jury would like to see you be super aggressive. Sometimes people love aggressive lawyers, but you should not do that. Kiwi C, thanks for the super sticker. All right. So what prejudice results from telling a jury the wrong standard? Well, if they knew what a standard was and they could actually understand it, it's pretty obvious how that could prejudice a situation if you give them the wrong standard. I've had defense attorneys misstate or misexplain the standard of proof and jury selection. I object. We talk about it. If there's a disagreement, sometimes the judge will have to hop in and read what the actual standard is, what the actual burden is to the jury, just to make sure they're on the same page. So it is very important to get that right. Very important to get that right. Sorry, my eyes caught a troll in the chat. Typically, courts give the jury a standard, and it is expected to follow it, even where attorneys may misstate the standard in their arguments. Okay, sorry, I didn't read this part, so I just didn't need to tell that story. Finding no prejudice from the defective instruction, in part because the jury previously was told the proper standard. Unfortunately, that did not happen here, where a jury has been misled as to the standard to the defendant's detriment. Courts find fundamental error because the error goes to the foundation of the case and takes away an essential right. I agree with that if it is misstated. Because the grand jury in this matter was only informed of the improper standard, it was fundamental error, necessarily depriving Mr. Kohberger of an essential right. Fundamental error necessitates reversal, or in this case, dismissal of the indictment. If that is the case, and they misstated it, I agree. The grand jury was erroneously instructed with the standard required for a presentment. Thus, this court should treat the indictment as a presentment. Okay, there's one final wrinkle to this error that is worth considering. As mentioned above, there is in Idaho a thing called a presentment. It does not appear from the authorities in Idaho that this thing is well understood. However, in the words of one justice, it is the only sort of accusation any grand jury has ever produced. For the information of the court and the bar, a presentment is what our United States Supreme Court would call a term of art. Thus, although it never receives definition in the code, it has a definition that comes to us from the Field Code. The Field Commission explains, the commissioners have proposed two modes of proceeding upon the action of the grand jury. First, where the defendant has been held to answer the charge, and in no other case, the grand jury may, if they believe him guilty, find an indictment against him. Second, that if, upon investigation of a charge against him, whether originated by themselves or presented by another, they believe he is guilty of a public offense, they must proceed by presentment. The presentment is an informal statement by the grand jury representing that a public offense has been committed, which is triable within the county, and that there is reasonable ground for believing that the defendant has committed it. Upon the former, he is, of course, to be held for trial. But upon the latter, he is only to be held for examination before a magistrate in the same manner as if an information had been given to the magistrate in the first instance, and with the same opportunity for explanation or defense. So it sounds like they're saying a presentment would lead us down the preliminary hearing route versus the indictment by grand jury route. These provisions, though new in practice, are in principle no innovation. In the criminal code recently adopted by Virginia, a similar provision is contained. And it may be safely asserted that the principle contained in them is in consonance with the common law itself. In a late case in Pennsylvania, the office of the grand jury was stated by Judge King to be confined to the examination of such cases as were presented by the Attorney General after previous binding over by a committing magistrate. This doctrine was held in a case where a communication had been received from the grand jury stating that the charges had been made by one of their number, to the effect that one or more members of the public trust had been guilty of converting to their own use public money and asking that witnesses should be furnished to them to enable them to examine the charge. The spirit of the rule is embodied and carried out in the provisions proposed by the commissioners, continuing in the grand jury all their powers in respect to the investigation of charges of the crime. It is proposed to guard against the hasty and ill-advised accusations by giving to the defendant upon presentment by the grand jury, where he has not been already held to answer, the same opportunity of answering or explaining the charge as if he had been proceeded against by an information before a magistrate. While, on the other hand, he is to be committed or bailed upon the presentment in precisely the same manner as upon an indictment. In this manner, the rights of the defendant are protected and the demands of the public justice are abundantly answered. Note, the presentment originates within the grand jury, requires a lower standard of proof, and requires a preliminary hearing because of it. Okay, basic argument here. Basic argument is you can do the grand jury indictment, or you can do a preliminary hearing, or you can do this totally unnecessary step by going to a grand jury, getting a presentment, and then doing the preliminary hearing anyways. Why would anybody do that? It is a total waste of time, money, resources, grand jury time. I honestly have no idea why you would ever do this. Usually, lawyers, when we look through stuff, we try to simplify it. We try to streamline it. We try to get uniformity so everybody knows what to expect. This to me makes no sense logically. And if this was the law, I'd be willing to bet the legislature would change it. All right, a presentment permits the defendant to request a preliminary hearing. A magistrate is to proceed on a presentment as if it were an information. At first glance, this likely appears to undo much of what has come before. After all, if a presentment is an information, then it has already had a preliminary hearing. However, history being what it is, things are not so simple. Ain't that the truth? In 1887, when the revised statute were adopted, an information was the same as a complaint. So now they're saying, hey, Idaho, what you guys thought was an information is not actually an information. An information or a complaint is a paper charging a defendant with a particular offense, and it matters not what it is called or whether it is called an information or a complaint. So basically, they used to be the same thing. Charging document a lot of times is what you use because it can be a criminal complaint, it can be an information, it can be an indictment. Once arrested on an information, a defendant had a preliminary hearing referred to at that time as an examination. It was not until the code was revised, certainly not for the first time in 1969, that the terms became truly separate. Additionally, even in 1887, the word complaint was solely used in the code when discussing misdemeanors, while an information or complaint referred to a felony, at least in magistrate court. Some jurisdictions, that's still on point. New Chris. So basically, there's a chance he gets off. I don't think so. And even if they were to dismiss this complaint or quash this indictment, they would refile and they would do it again with a standard of beyond a reasonable doubt or a preliminary hearing or pick your poison. I think they win no matter which route they take. J9 Wheels. Peter, if he had a solid alibi that made it difficult for the prosecution to even charge him, wouldn't he be free right now? Not necessarily. A lot of times defendants have pretty decent alibis or think they have strong alibis, and the state just doesn't believe it. They don't believe their cousin's friend's sister who said he was with me. They don't believe, whatever. They don't believe testimony. Usually if you have like video, filming you sleeping at 3 a.m. When they think you should have been out committing a crime, usually if you have something that rock solid, then yes, you would not be sitting in prison. Bryce, I think the state wanted to avoid the preliminary hearing. I mean, obviously they did. It was their choice, right? They chose to go the grand jury route, which was within their rights. LTL podcast, stalling. I don't really know if they're stalling, right? They got a 6-month window. They try to file a motion to stay. We'll see if the court grants it. They've already filed the motion, so let's have the hearing, right? Welcome, Michelle. All right. Thus, the question becomes, did the legislature change Chapter 5 and leave Chapter 12 alone to purposely turn a presentment into an indictment? The answer is clearly no. Although the purpose of the individual bill seems lost to posterity, the 1966 court modernization plan and the 1969 court reforms are still extant. In 1966, the legislature wanted a modern court system. Part of that plan was to do away with the justice of the peace, police courts, and probate courts, and have a 2-tier trial court system. According to the Committee on Court Study, the intention was district courts and magistrates. The third major area of concern of the Committee on Courts and the Advisory Committee was to provide for a 2-level system of courts in Idaho. This is the heart of the preliminary report. It encompasses proposals that some may consider a radical break with tradition. However, the Committee on Courts and the Advisory Committee feel that this is a logical step that must be taken to put into effect the clearly expressed wishes of Idaho voters when they adopted the constitutional amendment in 1962 to provide for a unified and integrated judicial system. The proposals contained in this section of the preliminary reports have been prepared in separate sections for easier study. This section includes proposals to abolish the present probate, justice of the peace, and police courts, to create a system of district court magistrates appointed by district judges, to define more clearly the duties and authority in the administrative matters of the senior district judge, to reenact provisions for a small claims department of the Magistrates Division and to change the method of paying for the costs of jury trials in the district court from the county to the state. The plan never mentions the intention to make it clear that complaints and informations are separate, but it does mention that the Colorado system does so. Okay. So by not saying it and they saying that Colorado did, that means we didn't want to do it here. In 1969, much of the court reform recommended was made into law. Although the purpose of Bill 79 is not in the session laws. Its title in the index is Complaint, Definition, Contents, Transmissions, Delivery, as well as Complaint, Examination of Person, Lodging. Additionally, the legislature amended much of Chapter 8 to create the modern preliminary hearing, replete with new references to the complaint. No laws were passed affecting functioning of the grand jury. Since 1969, the legislature made various adjustments to the criminal procedure. However, not one law pertaining to a presentment has been passed since 1919. Probably because they don't use presentments anymore, right? It makes no sense. For these reasons, it is clear that it is clear again. I love when lawyers say that. Idaho Code Section 19-1207 still intends for a presentment to be treated as we would now treat a complaint containing a felony. Thus, if the court sees fit, it could simply remand the matter to the magistrate for the necessary preliminary hearing rather than going through a dismissal and having to determine whether the matter may be resubmitted to the grand jury. Now, doing something like that would reset the speedy trial clock, and that would give them more time, as LTL Podcast said. So what they're trying to do is quash this indictment. If they can't quash it, they want it to be called a presentment. And they're saying that because the standard probable cause is more in line with a presentment versus what they think should be beyond a reasonable doubt for an indictment. So therefore, indictment out because they didn't say the right burden of proof. If presentment is in, then that would mean if we're going under all this crazy old law, we would come back in and now it would go to a preliminary hearing if the defendant says so or demands it in front of a magistrate, which it seems like the defendant wants. Why would they want a preliminary hearing? We talked about a lot of this. They can get some information. They can take some cracks at some witnesses. They can see how the state presents their case. They can hear some arguments potentially. They just get some free information. And again, it would instead extend the clock and allow them to prepare more for the case. Allie B, this is so much to comprehend, but so happy to be here and thank you for covering this for us all. Obviously, I can't dig into and hit every point. I'm sure other lawyers like Emily and maybe Rob will be looking into this as well. I'm sure they'll hit different points, pull different things out of it. That's what makes this so great, right? That's what makes this whole thing called YouTube so great. Katie, okay, is this confusing for the lawyers here too? Yes. Yes. Pantuffle, can you just tell us what you drink from the cup? From this cup, it's just water. Just water for me. Diana, we need a Rob, Emily, and Peter live when Rob isn't in Vegas. The Daryl Brooks EDB live got wild. I would love to. It's always fun. It is always fun to hang with them. Deb Jackson Smith, maybe he is really not guilty. Sounds like his lawyers are convinced. I don't know if they're convinced, but this to me sounds like an argument they would make regardless of guilt or innocence. This is a procedural argument, basically, what people like to call words are fleeting here, and I'm losing it. A technicality. This would be called a technicality if he got off on something like this. But again, they would just refile and do it again. Rob, keep state prosecutors litigating motions under speedy trial constraints. Lots of research for a response. Not far from papering the defense to death leading up to a trial. Don't hate the chess move. I got to be honest, Rob. I personally think this would be one of the easiest motions in the world to respond to. I bet there are so many cases that say it's a probable cause standard. I bet there are so many. I bet Judge has already ruled that that's fine. I bet that to overturn this would mean to overturn thousands of other cases. So I don't know. I don't think this is going to be the hardest one to respond to. It could take time, like you're saying. So that's fine. If that's what they're trying to do, that's fine. Also, call me a stickler. Inappropriate. Not why you're supposed to file motions to make the other person waste time. A dilatory tactic is what they call that. But hey, Rob likes a chess move. He's a litigator. He knows how to win these cases. Don, this case makes me rethink evidence. Not sure if I'm right. In America, When can we expect a response from the judge to this motion? So the judge isn't going to respond to this motion. The state will. They'll have a hearing on it, and then we'll hear what the judge orders. Net woman. All this research of the history of U.S. and England law was what Kohberger was doing on November 12th and 13th. Okay. Maybe they had help from their client. Is that what you're saying? I don't know. All right, let's get to the conclusion here and be done. Over 150 years ago, Idaho joined the state of California in adopting the Field Code, therefore adopting reforms to the grand jury system intended to restore to that system its function as a bulwark of freedom. The strange history that follows in this state, just as every other state with the same statutory scheme, is both tragic and unconstitutional. No court had the power to decide that the legislature had made it too hard for grand juries to do their work and change the sufficiency of evidence required to indict. Mr. Kohberger is asking this court to recognize the long string of error that has led us here and give back the people of this state the protections they are owed. The indictment in this matter should be dismissed or remanded for a preliminary hearing. These sound like losing arguments. I'm just gonna cut to the chase. These sound like losing arguments. I bet, just again, because we're going through some law changes in Florida, and I know how we're fighting these. I bet that this was already litigated and fought about when the court clarified and gave the probable cause standard. I guarantee this has already been argued before my time, before I was alive. I think this said 1969. I just don't see how this is going to be successful. I don't know if the court's going to grant another, temporary stay or whatever, so we can get this to hearing. If I was the state, I would want to respond to this as quickly as possible, get this set for hearing, get the judge's decision. So I know a lot of other things were filed. I'll be checking them out. Maybe we'll talk about them tomorrow, maybe this weekend, maybe next week. We will get to them, especially the state's response to the alibi. They filed another motion to stay. There's more motions to compel, discovery, and things like that. But to me, this is a losing argument. I've been wrong before. Not saying I'm for sure right. That's just how I feel. Brooklyn Basement, how do you respond to that? Honestly, I just go through the fact that hundreds of cases, thousands of cases, grand juries, magistrates, judges, lawyers, prosecutors, defense attorneys, all agree on this. To turn this on its head would be insanity. Judges do not like to create insanity. I don't think this would be that hard to respond to, honestly. There's probably so much case law on their side. And of course, they have the rule that the judge, they have the ruling from the judge that says probable cause. Idaho Code 6.5 or whatever it was. Azam, you're still here. I need to start from the beginning. I am at the workshop since 8:30. I tried to listen just now, but it's too loud here. Oof, Azam, get ready. Get ready for a whirlwind here. It's a wild ride. Oh, yeah. I guess we can mention off the back end here. Shabusiness is not insane. Shocker. She is responsible for the crimes in a lightning quick verdict. Back-to-back lightning quick verdicts. No surprise to me. So that happened in other news. All right. That's it. I love you all. Thank you for joining me last minute here, coming to hang out, and ask questions, leave your comments, hang out in the chat is always so fun. I appreciate you all. I'm out of here. Tomorrow's Friday. Hope everybody has some fun weekend plans. But that's all I've got. Tomorrow night, don't forget 250K subscriber special, the golf video to end all golf videos. Maybe. All right, I'm out of here. Thanks for joining me. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.